All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We are here today on our case number 1CACV150836, ABEL Commercial Ventures LLC versus ALINIAZEE. So, counsel, as you know, both sides are allotted 20 minutes for your argument. The appellants may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful if you would give us your name and the name of your client. We've read the briefs a few times, and we've studied the record. We've also discussed the case in our conference. So with that, Mr. Roth, you can proceed.
Thank you, Your Honor, and good morning. I'm Clifford Roth. I'm here with Joseph McCabe on behalf of the appellants, ABEL Commercial Ventures and Wigwam Crossing, also referred to as ACV and Wigwam. As the court requested in its order of last week, I plan to focus on the order that granted the ALINIAZEE's motion for summary judgment, that granted summary judgment on the remaining claims. Their motion was filed on March 5, 2014, and then answer whatever questions the court may have with respect to some of the other issues. I plan to reserve 5 minutes for rebuttal and the cross appeal on their denial of fees. Knowledge amounting to acquiescence. If you remember nothing else from my argument today, I hope you will remember those 4 words: knowledge amounting to acquiescence, because that is the proper test for liability for a person in Mr. ALINIAZEE's position, who was a corporate officer of Civica Development, and Civica was the manager of the 2 LLCs that were the plaintiffs below. The test is set forth in the Keems case as well as the Hall case and many other cases that follow the same rule, that there are essentially 2 paths of personal liability for a corporate officer. One is to directly participate, and then the other is to have knowledge amounting to acquiescence. And the knowledge standard obviously is a lesser standard, and the trial court erred in failing to apply that lesser standard and instead focused on actions and participation by ALINIAZEE. The inquiry, as stated by the trial court, was whether ALINIAZEE committed fraud, knowingly participated in fraud, aided and abetted fraud, or breached any fiduciary duty. And that's, again, from the minute entry. And again, knowingly participate in fraudulent conduct is a different and higher standard than knowledge amounting to acquiescence.
Well, we review that de novo, so we're...
Absolutely. So there's no indication that the trial court applied the correct test, and we believe that in their answering brief they have not explained away that legal error. The second legal error is a related one that shows that the trial court, again, was not applying the correct standard, is that he was essentially allowed out of the case because he played some administrative role. Not only was that a misapplication of the law, because even administrators are liable if they have knowledge amounting to acquiescence. It is contrary to the facts that show that he was much more than an administrator.
Well, let's talk about your specific claims. Why didn't the February or March 2008 letter demonstrate, as to the first claim, that the claim for fraud is barred by limitations? The management fraud, the fraud relating to the fact that Civica was taking management fees.
Okay. Well, That is an earlier ruling than the one I was addressing with respect to the summary judgment on all of the remaining claims, but
Well,
I'm
just-
happy to
I mean,
to focus on that statute of limitation. The claim did not accrue because the plaintiffs did not have knowledge that the defendants had engaged in fraud.
That letter's pretty compelling, though, right?
Well, the letter indicates that there were disputes over management fees, certainly. And the concerns over that are all based, if you read the letter carefully, based on the interpretation of the operating agreement and whether that operating agreement allowed management fees to be paid from loan proceeds. And there were disputes over the timing of the taking of the fees. But those don't establish the elements of fraud, and under the Thompson case, you need to consider the actual elements of the claim.
What was the fraudulent statement that was alleged in connection with the taking of management fees?
At the time of that March 2008 letter, the dispute was contractual as to whether the operating agreement allowed them to take it. Later, and there were promises that they would true up and adjust and reimburse the management fees.
Is that what the claim is based on, that a false statement made without intent to perform?
It's broader than that. The actual fraudulent scheme, as alleged in the management fee fraud scheme, was that they were never qualified to be developers, that they induced the plaintiffs to invest only to take out loans to pay management fees without a real intent to develop the properties. They extended the loans and did not develop the properties, and they had no cash flow from which to repay the loans. So it was a scheme where the manager was only interested in management fees and violated its duty not to commit fraud to the entities that it was managing.
That's a breach of fiduciary duty.
Conflating the later fraud claim, and I understand you're answering Judge Johnson's question, but as I understood the fraud claim that we're talking about vis-a-vis the statute of limitations, that was based on the terms of the operating agreement, correct? You have a later fraud claim that we want to talk about that was based on the M&I policy that your clients say was not disclosed.
I don't view it as being limited, excuse me, to the operating agreement. I think it's fraudulent conduct. And the reason
How did you plead it, though? I think you pled it based on the operating agreement. You had to plead it with particularity. I mean, I understand the other claim involves the M&I issue, but we can look at that.
We can move to the M&I issue. I didn't want to divert our time here.
Yes, and certainly we had 3 opportunities to file a complaint that struck a proper balance between particularity and conciseness. And the management fee claim is specifically and particularly alleged, and you can review that in the second amended complaint, which is CR95.
Okay, so moving on to the claim that Mr. ALINIAZEE fraudulently induced your clients to invest in Wigwam. What was the fraudulent statement made in connection with inducing your clients to invest? The validity of the pro formas that he
Certainly. He admittedly prepared the pro forma that was given to the members of Wigwam.
A pro forma is not a promise.
The content of it is when it's
no. That's not what a pro forma is. A pro forma is what we expect how things will turn out.
And when he prepared that pro forma, and Mr. Rose, the manager of Civica, gave it to them, saying the rate of return, internal rate of return expected, is very conservative. They relied on the detail of that presentation to have that expectation that that would be the result of their investment.
And what evidence did you offer on summary judgment to support the proposition that Mr. ALINIAZEE knew that was a false statement when made?
As to at the time, I think you have to look at the entire context and view that as promissory fraud, and you look at not only these 12 loans that were with M&I, but the total of 40 projects, all of which were lost in foreclosure.
The claim is based on fraudulently inducing these 2 investments. I mean, with respect, it's a horrible shame that your clients lost all this property and all this money. But on summary judgment, it was their burden to offer evidence that Mr. ALINIAZEE knew the pro formas were wrong.
Okay.
And what evidence was offered on that?
I think you just have to look at the entire circumstances, and he just basically pulled numbers out of the air to without foundation, without the experience of being an experienced developer. He's just making a promise without any foundation, while at the same time he and Mr. Rose giving the image that they were qualified to run the business and create those levels of return.
Well, was a document such as that presented to the trial court? I'm getting to Judge Johnson's. Where is that document in the record for us to review, other than you have to look at the, I don't know what you said, 40 types of transactions that took place? Is there a document in the record that you can point us to that goes to Mr. ALINIAZEE knowing that this was a fraudulent promise?
I have no document that I can point you to that shows that knowledge at the time. We have voluminous attachments to the response to the summary judgment motion, as well as the motion for new trial that outlines the entire course of conduct. And I don't think, fine, you're focusing on the developer fraud claim. And we admitted that ACV was properly granted summary judgment against ACV's claim on that because we could not prove Mr. ALINIAZEE's involvement early enough. So we're only dealing with Wigwam on the developer fraud claim. What I would like to do is to provide to the court a short collection of exhibits that were before the trial court at the time of the summary judgment ruling, and track through that to show the other types of fraud, including the loan fraud with respect to the increase of the Wigwam loan and the developer.
That's the one we're particularly interested in knowing about, or that I'm particularly interested in knowing about.
With the court's permission, copies for the court and counsel.
Thank you. Are these all in the record?
They are, and they are all exhibits to the statement of facts in response to the motion for summary judgment, which is CR2 Let me just briefly go through here in the interest of time. Exhibit tab number 1 shows that Mr. ALINIAZEE, and the thrust of their motion for summary judgment was that Mr. ALINIAZEE really wasn't involved. He only engaged in ministerial activities. He was merely an employee. And this shows he was not only the CFO of Civica, he was the CFO of its holding company, a more prestigious position. The second tab shows one of the key factual events in this case, that M&I Bank, the lender, which had a dozen Civica-related loans, figured out before the beginning of 2008 that Civica was engaged in a fraudulent scam to take management fees for sitting on vacant land. And if you look at the highlighted language in the second page of tab 2, it shows that M&I Bank blew the whistle and changed its policy to prohibit further payment of management fees unless you had a budget approved before the beginning of 2008. The problem was that the bank told only Civica, the manager, that was improperly taking management fees, and didn't tell the investors, the members, about the policy change and the reason for the change. An even bigger problem was the fact that Civica didn't tell the plaintiffs about it. And we believe that the summary judgment record contains ample evidence to show that Mr. ALINIAZEE personally and fraudulently concealed from Wigwam's members the fact that the bank had become aware of this fraudulent management fee scheme and the underlying reason for that. And we can look at the next exhibit, which is a deposition excerpt from Mr. ALINIAZEE that shows that he said under oath that he was aware that the bank told him about the change in policy either in December of 2007 or January of 2008. The inference from that, since he said December 2007, The inference that must be drawn in favor of the plaintiffs is that he was aware of that at the beginning of the month, December 1. The next document at tab 4 was Exhibit 10 to the Statement of Facts, and these are two emails from Mr. ALINIAZEE on December 3rd and 4th. If you look at the first one on December 3rd, which is on the second page, it shows that he is expressing urgency, that it's imperative to get NBA and HOHOCOM, the members of WIGWAM, to sign the documentation as soon as possible. And the reason given is to avoid any funding delays. And that was sent on December 3rd. If you flip back and look at the follow-up email on December 4th, he's further pressing the issue, stating that the bank needs to have the document executed so they can table or earmark the funds for the loan. And we submit that a reasonable juror could conclude from these exhibits at tabs 2, 3, and 4 that ALINIAZEE knew by December 3rd, 2007, about the bank's change in policy effective at the beginning of 2008, and that the real reason for the urgency was not for funding delays. It was to allow Civica to obtain an amended budget that allowed payment of additional management fees. So before the loan was increased, the members were entitled to know about that change of policy, especially since they were direct borrowers at the time. Instead, through concealment and misrepresentation, Civica was allowed to continue to feed at that management fee trough and keep secret the fact that the bank had discovered the scam. And that caused enormous damage to WIGWAM because they had the opportunity to pay off the loan when it became due in January of 2008. And instead, they increased the loan, which reduced the amount of equity they had in the property, and also extended the time period for repayment, which allowed the market declines later that year to come into play. And ultimately, the properties were lost. Both WIGWAM and ACV's properties were lost at foreclosure in 2009. Unless the court has questions, I better reserve the rest of my time.
Well, I've got a question about what evidence there was to support your client's contention that Mr. ALINIAZEE was aware of a fraudulent statement made in connection with the final transaction, the offloading of the loans to SWN.
That issue is addressed in the remaining exhibits that we've attached here,
Well, I've seen Mr.
5, 6, and 7.
Kurgan's statement, but I don't see anything tying that to Mr. ALINIAZEE, that he had knowledge of that purported fraud.
The exhibit at tab 5 is a request from Mr. Rose to the bank, which was copied to Mr. ALINIAZEE, and I'm looking at page ACV 150836, in which
Right, he's setting up a meeting.
He's setting up a meeting to discuss the sale of the loans, even though he knows the investors, which are the members, are going to insist that we do everything we can to protect the properties, including litigation in Chapter 11.
I don't see that tied to Mr. ALINIAZEE, but
Well, he's copied on that email. He knows that they're going, instead of protecting the investors, they're going to pursue a sale to the loans to Mr. Rose's friends.
We know Mr. ALINIAZEE read this email?
We don't. You can look at the last email in the string, though, which is an email from Mr. ALINIAZEE to a representative at the bank talking about the extension period. And there's voluminous other documentation that shows that Mr. ALINIAZEE was involved in meeting with Southwest Next and providing them information to pursue the loan sale. Again, the next exhibit, tab 6, shows that the intention on December 11 of 2008 was to obtain the consent of the members. They decided that there was too much risk that the members would interfere and kill the deal. So they didn't obtain consent. They didn't even conceal the loan sale transaction until the night before it closed. And Mr. McCurgan's letter, the last page of the packet, again confirms that the plaintiff's members were deliberately excluded from the loan sale discussions because of concern that they would have disrupted and likely have killed the deal. So you've got a manager and a sub-agent, Civica and Mr. ALINIZEE, deliberately excluding the decision makers of the principal to do a transaction that resulted in Southwest Next obtaining the loan discount. Southwest Next bought the loans at enormous discounts. That is a corporate opportunity that Civica should have allowed to the two plaintiffs. And instead, they committed fraud, they concealed it from the members, and provided a huge benefit to the Southwest Next parties.
Thank you.
Thank you.
Good morning. My name is Philip Whitaker. Mr. ALINIZEE is here. I am the lawyer for Mr. and Mrs. ALINIZEE. I greatly appreciate the notice we got last week to limit what I had to prepare for, although I had started preparing, quite a ways before. This case came up, and I filed my motion after sending Mr. Roth at least 2 letters saying, what is this fraud you're talking about, and how is he tied to this? And he did an initial disclosure statement, and I wrote to him and said, he's scarcely mentioned in it. Tell me what he did. And he sent me a first supplemental disclosure statement, and this was Exhibit 4. I'd like to read to you part of his disclosure. On page 17, he says, in his letter dated 8/5/13, counsel for the ALINIZEE defendant states that Mr. ALINIZEE is scarcely mentioned in your client's initial disclosure statement. To further understand the scope of ALINIZEE's broad involvement and acquiescence in the misconduct alleged in the second amended complaint, counsel, me, I should go review the numerous emails sent or received by ALINIZEE, and I should do a research, which at that time was over 115,000 documents, for ALINIZEE in the voluminous documents produced by plaintiffs. So he was telling me I could go do it. Suing Mr. ALINIZEE for millions of dollars. He got a default judgment against Civica, and he wants to tag Mr. ALINIZEE with this. And that's his answer. And that was shameful. And I filed my motion. A month later, he takes Mr. ALINIZEE's deposition. A month later. All these exhibits he showed you, not one of them was used in his deposition. I attach as Exhibit 6 to our objection to statement of facts Mr. ALINIZEE's entire deposition, not the exhibits, but on the front page it lists all the exhibits. The court compares it. He didn't ask him about one of these. What he wants is adverse inferences drawn from bare facially neutral records. That's what he wants. He didn't attach testimony of a single witness. There were 13 depositions taken in this case. He didn't attach a single deposition exhibit discussing these exhibits he claims are so crucial.
Well, what was the evidence? Let's talk about the decision by M&I not to allow any more draws on construction loans for management fees unless there was construction. What's the evidence that his clients knew with before limitations ran that of that policy change? Because that's a scenario in which there is
Yeah,
direct evidence
Well,
by Mr. ALINIAZEE.
there's an email that Mr. ALINIAZEE wrote on December 3rd, 2007, to Ms. O'Connell. Mr. Roth wants to tell you that it was a bald-faced lie that there was urgency by the bank to have those signed. There is not a single thread of evidence anywhere that says that statement was false. Not one bank employee testified that was false. There's no email suggesting that wasn't true. Mr. ALINIAZEE was never asked. There is zero, and I mean zero evidence.
But I think the claim is more of a failure to disclose claim.
Yeah.
They
And
had a
then
duty to disclose and didn't.
So that was one point of this email. They claim the excuse was bogus. There is zero proof it was bogus. This is his argument, and he'd never even asked the questions.
Well,
Okay.
I mean, separate and apart from whether he cross-examined your client about it, his deposition, the claim, I think, is that as an officer of the manager, your client had a duty to disclose bad conduct by, and the real reason for rushing to get the extension agreement signed was that they would be grandfathered in so that Civica could continue to pay its management fees.
David Block was the loan officer. Okay. And he was questioned directly about this. And David Block said that policy was announced in January of 2008. The email was sent a whole month earlier, December 3rd, which would have required disclosure to Mr. ALINIAZEE probably in November, if Mr. ALINIAZEE had known. David Block says, I did not tell Mr. ALINIAZEE until February 12th. We had a closing on Angelwood. And at that time, I told Mr. ALINIAZEE.
Is that, so Mr. Block testified that was the first time that he told Mr. ALINIAZEE about the change in policy?
Yes.
Where's that in the record?
It's in my objection to statement of facts, my additional statement of facts.
Okay. Because your client testified that he thought he wasn't sure, but he remembered he heard in December or January about the change in policy.
What happened is Mr. ALINIAZEE was deposed outside of this case several years ago without reference to any records. He's just sort of asked when. And Mubin says, well, yeah, I heard about it December or January. I mean, that's his answer. There's no reference. He was not asked, boy, you know, when you sent this email on December 3rd, did you know? He was not asked, did you know about this before December? He wasn't asked, did you know about this in November? He was just asked generally, did he hear about it? And Mubin says, yeah, January or December.
What,
That is, Your Honor, the only evidence in the record, the only evidence that would say it was before February or January of 2008. Mr. Block was very firm. He says, I wouldn't tell anyone what a policy is until it becomes actually announced as the policy.
okay.
And I remember meeting on the Angelwood closing, and that's when I told him. And he is
He's the guy.
bank guy who would have told Mr. ALINIAZEE.
There's an M&I loan presentation dated June 4th, 2008 in the record. Is there any evidence that the appellant saw that about the time? No? Okay.
No, none at all. I mean, Your Honor, and
No, that would have helped your.
yeah,
That would have-
they've taken things out of context without any deposition testimony, and they say, look, draw these adverse inferences. Well, it's an internal banking memo. They didn't share it with them. And when the market crash hit, you know, everything went very quickly, and M&I was shutting down raw land deals as fast as they could. But the suggestion that when Mubin sent that email on December 3rd saying, do this, aside from his kind of a guess on his email, there's no evidence. And I want to point out, Your Honor, at no point in 2 depositions of Mr. ALINIAZEE, did they question him about that email?
I don't know that they're obligated to, are they?
Well, if you're trying to tie down the date, you'd want to tie down the date. If you want to say by December 3rd you knew, they utterly failed to tie down the date. And the one witness who knows absolutely denied it several times in his deposition, and that's David Block. The David Block deposition, Your Honor, is Exhibit 3 to our objection statement of facts, and his testimony on that topic is at page 107 to 110 and 138 to 139.
Thank you.
So, like I said, this was not a surprise motion. I told the plaintiff's counsel I was filing it. He had the opportunity to conduct depositions. He did conduct 13 depositions. Over 100,000 pages were produced. Not one of these exhibits was used in a deposition of Mr. ALINIAZEE. And one of the things he says, well, Robert McCurrigan of Lewis and Roca wrote a letter and said we're excluding them.
Counsel, you on tab 7 or 6? Where are you at?
7 of what Mr. Roth produced. There is no evidence that Mr. ALINIAZEE had any role in excluding anybody from anything. In fact, the one letter they point to that he wrote, he was asked by Mr. Rose to write a letter. His letter says, we owe fiduciary duties to them to preserve the capital. That's his letter. That's not fraudulent. That's saying we're preserving capital. And otherwise, if you look for anything Mr. ALINIAZEE authored, there is nothing there.
What about that Mr. Roth pointed out that he was copied on several of these emails that are at tabs 5 and I think it's 5 and 6, or at least 5. How does that connect, if it does, to knowledge amounting to acquiescence?
I don't think well, first of all, these are, I think, facially neutral. So, secondly, being copied is far different from being the one who's writing it. I think everyone agrees on that. And some of these where he got copied with everybody else. Like Exhibit 6, he's copied with Mark Diogari, who was the attorney for Civica, Alan Sparks, who was with Mubin, who simply, all the testimony is all they did was gather record for M&I. And as an aside, Southwest Next obtained a loan portfolio, which was 12 or 15 loans, because they made the highest bid. And that was in the bank motions before Judge Warner. They didn't get a low ball offer. They made the highest bid. And that's why they got it. And then when they foreclosed, they were on their own doing that. Then he talks Bill Pennington, who was the president of Civica, under whom Mubin worked, and Judith McCardle, who was the controller, who was the CPA, who did the books and wrote all the checks. And I forget who Kathy Robinson was. So he was copied, but he was copied with everyone else. And there's no hint here that fraud is afoot. There's no hint here that Mubin ALINIAZEE would have gotten a copy of this and said, fraud's being committed. There's nothing to suggest that.
I've got a question on your cross appeal when it's time to move there.
No.
The cross appeal for attorney's fees stated a number of different possible grounds for claiming fees. I'm curious about the ground under 12-34101 arising from the operating agreements. There's a law that says you can't recover fees on a fraud claim unless the fraud claim would not have existed but for the contract.
Yes.
I'm wondering, to the extent that the fraud claims were really, you failed to disclose to people that you had a duty to disclose certain things to, more, not alleged misrepresentations of fact, but more failing to disclose things that you were duty-bound to disclose, to the extent that the duty to disclose those facts would not have existed but for the operating agreement. Would that support a claim for fees under 12-341-01?
Yes, and I think we didn't have oral argument on it, but I think Judge Warner looked at it and sort of said, well, you have an independent duty not to commit fraud. You have, by misrepresentation or omission.
Well, or omission?
Yeah. So, and we do. We all have those independent duties, regardless of what the contract is. However, that ignores the context of this whole case, which the operating agreement permeates everything. And the reason duties he was in his role was he was working for Civica. So I don't think otherwise you would never get attorney's fees in a fraud case that ended up in with contractual grounds. The defense would say, whoever lost, you'd say, well, fraud's independent. It doesn't matter the context in which this arose. It doesn't matter if, you alleged all my duties arose out of an operating agreement or some contract. Since the form is a contract, that's the end of the story. And I don't think that's a proper analysis. I think you need to look at the context of the claim. And the operating agreement permeates everything. It just permeated the whole thing. And their claims against Mr. ALINIAZEE were, well, you're a sub-agent of Civica under the operating agreement. So I think I don't think it's the right approach fundamentally to say we're going to look at what the claim is called and ignore the context under which that claim arises.
Does the Carruthers versus Underhill case bear on your claim for attorney's fees at all? You remember that one?
Yes, although I got your notice, and so I was saving my cross appeal for the last couple of days, and I haven't read it in a while. I have to confess. I spent the last 2 days poring over the summary judgment record,
yeah,
so I'm very sorry. But I remember citing it. I think you authored it, if I remember right.
I don't remember.
Oh, what, did you?
I don't know. I wouldn't.
I was on
claim
that
it.
case.
Okay.
That's who you were with.
I didn't write it.
Okay. All right.
All right. Anything?
All right. Well, thank you very much.
Thank you. Thank you. Mr. Roth, I feel like I consumed your 4 or 5 minutes of rebuttal. So with the consent of my colleagues, Chris, would you add on 4 minutes to the time there? And
That's very
start
kind.
anew.
Thank you, Your Honor.
It's only fair.
I'm not sure I will need all of those 4 minutes.
That'd be
Again,
even better.
I don't intend to address the cross appeal. We have briefed that. I think the issues are very straightforward. Mr. ALINIAZEE is not entitled to fees under either 12-341-01 or under the operating agreement to which he's not a party. The issues that Mr. Whitaker addressed, he did not answer your question with respect to what evidence there is in the record to show that the bank's change in policy and the underlying reason for that change in policy, that they were essentially engaged in a scam to take management fees for sitting on vacant property in which they had no plans to develop in the next 12 months. He didn't answer that question, but the answer is there is no evidence because that was concealed. It was not disclosed prior to the September 13th, 2008 relevant date for the 3-year statute of limitations for fraud. You also asked about the M&I memo that is included in our packet, the memo that is at tab
Oh, that was that one?
2. and whether that was disclosed in a timely manner. And again, the documents show that the memo itself was obtained in litigation during the course of the case. The M&I-Rose Bates number reflects that. So the plaintiffs never saw this memo until they got it through discovery from the bank. And again, the underlying information that the bank had become aware of the management fee scam, that also was not disclosed until much, much later, and certainly after the statute of limitations date. The fact that we didn't tie down the date, we didn't need to tie down the date. We had Mr. ALINIAZEE's deposition testimony under oath that he was informed in December 2007.
Well, he says December or January. He thought he
December
knew.
or January. But again, there are hundreds of cases that on summary judgment, the inferences must be drawn in favor of the parties opposing it. And that means that the reasonable inference for that is that he became aware of that on December 1, 2007.
Would that be true even if Mr. Block supposedly said, no, I didn't tell him? till
Absolutely,
February?
Your Honor. That's a classic factual dispute where one witness says it happened then, another witness said it happened later. That's fine. That's a factual dispute. That precludes summary judgment. It's enough that ALINIAZEE himself gave the December date, and you can read his emails, the two emails that are included as tab 4, and the reasonable inference was that the reason for the urgency was he knew he had to get the bank to table and earmark that amended loan in order to obtain additional management fees. And he knew he couldn't dare disclose the bank's concern about the management fee fraud, because then the whole development and all 11 loans that our clients were involved, all projects that our clients were involved in, and all 12 loans with the bank arguably come crashing down if the investors find out that the bank thinks there's a fraud scheme going on to take management fees that are not being earned. The question, Your Honor, that you had, Judge Downey, with respect to being copied on emails. Again, let's go back to my first words. The test for liability of a corporate officer like Mr. ALINIAZEE for corporate torts is knowledge amounting to acquiescence. Being copied on emails is written evidence of knowledge. That is a starting point.
Knowledge, but acquiescence is a much higher standard.
Well, if he is the CFO in charge of all financial dealings of Civica, and admittedly in his answer, he testified that he is the man responsible for plaintiff's loans.
So he acquiesces to everything that's said in every email on which he's copied in that capacity? I can't see that.
I think acquiescence merely means that if you're the man in charge of finances and loans and you don't prevent it, that's acquiescence. He was in charge. He admittedly in his answer acknowledged that those were his roles. The reasonable inferences from that role itself, being the CFO and the person in charge of the loans, means there is a question of fact, because all of the claims in this case deal with financial issues and the plaintiff's loans. We would ask the court to reverse the trial court's ruling with respect to all of the rulings that we've challenged in our opening brief and affirm the denial of fees on the cross appeal.
Thank you.
Thank you.
Thank you to all the lawyers for your argument and for your briefing. We will take the matter under advisement. Now we will adjourn.